I just read this article about a client of Westbank that basically lost a car through repossession after Westbank had obtained a default judgment against this customer. This customer was in arrears with 76,000 rand for a Pajero. And Westbank basically went to court and applied for a default judgment, which is what the banks would usually do when you are actually in arrears with your vehicle. So now the bank was arguing basically in this matter that they did send the customer the Section 129 notice in terms of the National Credit Act. And they also called the customer and they spoke to the customer, and the customer actually dropped the phone, and they sent basically the notices through registered mail, and they also sent the notices through emails, and they even sent a field agent basically to go and speak to the customer and to tell him that he's owing the vehicle on the vehicle. And the customer said, look, I'm gonna pay once I'm able to secure employment. It means at the time the customer was not actually employed. With all that information presented to court, the judge was still not impressed. He actually basically decided in favor of the customer, even though the judgment was not so helpful to the customer per se, because the car had already been auctioned off, so you couldn't really get the car back. But I think the principle stands that what actually happens if you are not able to pay for the vehicle that you owe to the bank, and the bank come and actually repossess this car. What basically should they do to ensure that that repossession is actually correct and is in terms of the law? Because if they don't challenge this judgment and it stands, it's going to be used again in the future as a reference point. It means it's going to be difficult for banks to actually just go and take people's cars, basically, just for non-payment, which I think is going to be, I don't know, it's going to be an interesting thing to look at in terms of how is it going to impact the risk factor within the bank in terms of the lending. Because now it means they're going to have to be a little bit more stricter in terms of ensuring that whoever they're giving loans or money to buy vehicles or any asset for that matter, that person can actually pay for that asset. So it means it's going to get difficult, more difficult to get a car to buy, to get money to buy a car on finance, if basically that becomes the case, because the banks are going to be more cautious. They don't want to lose the money that they give to the people. They also don't want to lose the asset. So where does it put you and me as a person that want to go to the bank and actually get the money to buy the vehicle, if the banks are going to be even more stricter in terms of lending criteria, because they fear that the courts might say, well, you can't actually repossess the car because you can't prove that the person actually got the information that you sent them that they were owing at the bank. I think the matter is actually very interesting. I don't know what your take would be on this. I just read this article and I said, whew, yeah, it's really getting tough out there for basically everybody. Even the banks have got to face the law, and they're not able to get away with things that they think they may actually are able to get away because of the financial master that they actually have. So, of course, unless this decision is taken to a higher court and is overturned, it will stand and it will form part of the case law going forward. And it means a lot of people will be able to have their cars not repossessed, even if they're owing, as long as the bank cannot prove that the person the person actually did receive the notice that they were owing and that the bank was intending to repossess that vehicle. What do you think of this case? I don't know. What do you think is going to be the impact of this case on the lending market as a whole, but more particularly for motor vehicles?